Good morning, everyone.
Morning.
Well, it's good afternoon. Time flies. Welcome to yet another RAC meeting. It's possible this one will be a little shorter than the last few. We will start with Casey doing a roll call.
Okay, if you can just indicate whether or not you're present. Adam Abplanalp. Beth Woodard. Brenda Sanchez. Brenda, it looks like we have
I'm
you.
here.
There you
I'm
go.
here. There we go. Sorry.
Carolyn Shields. Courtney Sneed. Chris O'Grady.
Present.
Raghav Shan. Gabe Shepard. Asina Wittenberg. Jeb Ladine. Joe Barker.
Gabe Shepard is joining.
Corey Tate.
Here, thank you.
Chris Wright.
Here, thank you.
Liz Fouther Branch. Mallory Roberts. Matthew Call.
Here.
Michelle Smith. Nancy Sandoval. Rob Bovet.
Present.
Sarah Zavala.
Present.
Scott Winkles.
Present.
Sherry Kinsey. Therese Holmstrom. Tiffany Johnson.
Jeb Ladine is here.
Thank you, everyone.
Okay, everyone just hold on a second because my audio is problematic. I mean, shows it all the way up.
Could someone say something, please?
Hello.
Hello.
You guys are saying something. Awesome.
Hello.
We cannot hear you. Microphone, same as. Could you say something again?
Good afternoon.
There's also two comments in chat. I do believe one is from Gabe Shepard.
Yeah, just saying I arrived after my name was called. Hello.
Hello, Gabe.
About that delay, everyone. Okay, so now in the roll call, the idea for today was that we would begin with where we left off last time and get through the last rules that we had not covered in the previous meeting. And then we'll take a break and then we can discuss any additional thoughts or comments on the other rules. So when we had left off, we were just finishing up 199.050.0080, the training rules, and we were about to begin, or 0085, and we were about to begin the Division 40, one amended rule and one new rule. So with that, I will let Casey read and we will begin.
Okay, Division 40, Executive Session, 199.040.0027, Employment of a Public Officer, Employee, Staff Member, or Individual Agent under ORS 192.6602A, in compliance with ORS 192.6607D. The purpose of this rule is to provide guidance to a governing body when the governing body holds an executive session permitted by ORS 192.6602A. to consider the employment of a public officer, employee, staff member, or individual agent. Only consideration of an initial employment is permissible under this section. ORS 192.6602A does not authorize decisions, deliberations, or discussions of other employment actions such as performance evaluation, complaints, discipline, termination, or extension of an employment contract. As provided in OAR 199-040.00203, compensation, including salaries and benefits, may not be discussed or negotiated in executive session. Sub 2, employees and staff members. Before a governing body convenes an executive session to consider the initial employment of an employee or staff member under ORS 192.6602A, the governing body shall A, advertise the vacancy, and B, adopt regular hiring procedures. Sub 3, other public officers. Before a governing body convenes an executive session to consider initial employment of a public officer under ORS 192.6602A, the governing body shall satisfy the requirements in subsection 2A and B of this section, and B, offer the public an opportunity to comment on the employment of the public officer. Subsection 4, Chief Executive Officer. Before a governing body convenes an executive session to consider initial employment of a Chief Executive Officer under ORS 192.6602A, the governing body shall satisfy the requirements in subsections 2A and B and 3B of this section, and sub B, adopt hiring standards, criteria, and policy directives at an open meeting at which the public has an opportunity to comment on the standards, criteria, and policy directives before such adoption. Sub 5, the prerequisite to offer the public an opportunity to comment on the employment of the officer means that the governing body shall provide the public with an opportunity to comment on the filling of the public officer's position. It does not require that the public be given an opportunity to comment on named candidates for the position before the executive session is held. Sub 6, when a governing body convenes an executive session to consider the employment of an individual agent under ORS 192.6602A, the agent shall be an individual person. Some examples may include an attorney, an accountant, or other individual who would perform services on behalf of the public body in the capacity of an agent, even if the prospective individual agent works for a larger firm or company. A firm or business entity that consists of more than one person is not an individual agent, and a governing body shall not consider the employment of a firm or entity in executive session under ORS 192.6602A. It is not required that the governing body fulfill the prerequisites listed in ORS 192.6607D when considering the employment of an individual agent in executive session under ORS 192.6602A.
Okay, so My thoughts in making the changes I made to this rule were I rearranged it based on some of our prior comments and conversations to sort of start with the basic requirements for just employees and staff members, then go to public officers, and then the chief executive officer. And I endeavored to eliminate some of the redundancies, though not sure I succeeded. So any thoughts or comments? Gabe?
Yeah, so when I first read through this, I'm looking at the very beginning of the bolded changes that refers to OAR 199-040-00203. Yes, what's on the screen. I referred to that OAR, I read it. I think there's a lot of misunderstanding about what this OAR covers amongst cities right now, because most cities that I'm in communication with use executive sessions to discuss salary changes to their chief executive officers as it relates to performance reviews. Does someone merit under ORS 192-660 to what is that? It's not to A, it's to H or F or one of those ones. It is about performance reviews of an officer that doesn't request an open hearing can be done in executive session. And as a part of that, performance related compensation is discussed. So I'm just personally confused about this section we included here and this other section, the other OAR that it references. And if the interpretation is that no salary can ever be discussed during executive session.
A good question. I think the answer is yes, that no salary may be discussed. I mean, the 040 subs, OAR 199-040-020 sub 3, that has been in place for a number of years, and is based on the guidance in the AG manual as well. So salary is not supposed to be discussed as part of a performance evaluation or when initial hiring, or I think what the rule your eye. So
Okay.
part of my purpose in putting this here, and just in general, I mean, I dread the idea of doing all of this again, but at some point we will have to do another rulemaking process, and we'll probably at that point endeavor to kind of combine the existing 040 with the public meetings law rules, since it really is part of public meetings law. But anyway, the answer on that is don't talk money, don't talk salaries in an exec session.
Okay, thank you.
Does anyone, I shouldn't ask this question, but does anyone think that the rearrangement here and the sort of breaking it down the way we did makes it any more understandable? I mean, because the subsection 7D has kind of always been a problem based on some of the cases we see here. And I would like to give you all a good explanation for why we are not defining public officer. I'm not sure I can adequately explain it. There are apparently numerous legal impediments to us defining public officer. Okay. If there are no further comments on 27, we'll move on to 60.
Okay, 199-040-0060, prohibition on making decisions in executive session. Unless otherwise authorized by statute, a governing body shall not make a decision or vote in executive session. A governing body may reach an informal consensus in executive session, but any decision or vote may only be conducted in open session.
Yeah, and as previously explained, my main purpose in this rule, obviously it's in the statute anyway, that can't make a final decision or take final action. My point here was to sort of have the rule clarify that you can reach that informal consensus. Any comments or questions on 040-0060? Okay, so for next section is Division 8, Compliance and Sanctions. And the rule is 199-008-0015. Don't think we have to read the entirety of the rule. I'm hoping we don't. The only change in the rule is in subsection 2, where we changed from just being the executive session statute. So subsection 2 now reads, Table A lists the factors that the staff and commission may consider as mitigating or aggravating any violation of Oregon government ethics laws in ORS Chapter 244, Oregon lobby regulation in ORS Chapter 171, or, and the new part, Oregon public meetings law in ORS Chapter 192. So that is the only change made to this rule. But what this rule then allows is Table A and Table B, which are made part of the rule. This is that penalty matrix that we have discussed previously that the commission uses for all of its cases when either imposing a penalty or a sanction or negotiating a stipulated final order or so. Two changes that I have made are, let's start with under the row I think it's the 10th one down, advice sought and followed prior to violation. Does everyone see that? And it specifically says agency -1, agency counsel -2, and then previously it said OGEC -5. And it applied to all 3 areas of our jurisdiction. So I took to heart Scott's comments, this is a couple meetings ago, about why are we saying we're going to deduct 5 points if they're following OGEC's advice? Because in the advice statutes, whether it's the informal letter of advice or a staff advisory opinion or a commission advisory opinion, those statutes themselves specify that if they are acting on the advice of OGEC and following that advice, that there cannot be, realistically, there could not be a civil penalty. The only sanction that could be imposed would be a letter of education. So the other motivating factor here is, I can certainly say in my recollection in the 6 years here, I don't recall a single penalty matrix where we had an opportunity to even apply this provision. So I agree with Scott. I think we take out the OGAC -5. Does anyone have any thoughts or comments on that?
Thank you.
You're welcome, Scott.
Yes. Should there be some points for going to, going to the committee at all? Would it deter people taking it completely off from going to the commission to ask for
Advice. I
advice?
think so. Is this Joe? Sorry, I couldn't tell. I don't think so, Joe. I think that's a valid point, but we get a lot of requests for advice and a lot of phone calls every single day. So I think people are motivated to ask for the advice, and then especially because in the advice statutes, 280, 282, and 284, they specifically provide that sort of safe harbor. So I think the motivation is there in the statute already. Having it in the matrix, I don't think it needs to be there.
Okay. I was
Scott,
just
you have
wondering.
something?
Thank you.
Yeah, I do. I'm trying to remember the safe harbor statute for agency counsel.
Well,
And 2 still seems light to me. I think that I'm trying to remember because I thought there was a limitation on agents getting advice from agency counsel, which I think is going to be a lot more relevant to the commission as we get into the open meeting enforcement.
One 9685. One second.
So I guess at this point, while we have a lull, I see that you've also posted for tomorrow, July 23rd, a special meeting agenda for 4 p.m. to 4:30.
Yeah, I'll be talking about that in just a little bit.
Okay. Thank you.
I think, Scott, what you're thinking of is in 244.350, which is the commission's civil penalty statute. And under subsection 2, which is where we have the authority to impose penalties of up to $1,000 for public meetings law violation, 2B has that additional sort of safe harbor that a penalty may not be imposed if it occurred as a result of acting on advice of counsel.
Yeah.
Okay.
Which is, so, I mean, if you're pulling off 2 points, I don't know that gets you to, if that gets you to what's required in 350.
Okay. I mean, yeah. Realistically, I think where we have had that come up in terms of acting in an exec session case, acting on advice of counsel, I don't know that, because if they were acting on advice of counsel, I'm not sure we even got to the point of going through the penalty matrix. I mean, because if acting on advice of counsel, you can't impose a penalty, you can only have the sanction of a letter of ed.
Right.
But yeah, I'll play with that. 350 and see if we need to tweak this to clarify that. Okay. The other change made here is adding the last row, which is action to prevent future violations.
Alright,
Obtained training. And and then a -1 that would apply to all 3 areas of our jurisdiction. So a couple points to say here. In a previous version during rulemaking, we had explored whether to add lines for sort of, was it a knowing or intentional violation? And then maybe other deductions for it. Was it just a minor infraction, or I forget how I phrased it, but the problem is that it's very hard to, one, DOJ keeps reiterating knowing is not a standard in the statute that we can apply. So what I would say is, and then the other thing we had was sort of that cure provision, has the public body made an effort to fix things? I had previously removed those sort of cure, and DOJ doesn't like me calling it cure, but cure provisions in the rules and just let the statute be where it is. What I will say on the cure provisions is the second to the end, this has been in the penalty matrix for a number of years, that where a person has taken an action to rectify before the complaint. So if I'll think of an example, if a public official, well,
we had a city council, they took public meeting, or they took executive session training while you were doing the investigation.
yes, so well, that's the example for obtaining the training. So if you receive a grievance and you responded in the 21 days, and part of your response was, I think you, grievance submitter, I think you were right. And here is what we're going to do to fix this. And part of that is we're going to get additional training. So I want to give people credit for making the efforts to both prevent future violations and get the training that they need, whether it's from us or anyone else. Does that make sense? So we already have in the matrix that if they take action to fix things before the complaint is filed, you get credit. And then we've added, if you take action even after a grievance or complaint's been filed, but you're taking proactive measures to prevent this mistake happening again, and that may include getting additional training, we want to give additional credit for that as well. Thoughts, comments on the matrix? Nobody has any thoughts on the matrix? Okay. Well, that brings us to the end of the rules, and in an ideal world, I would have red line of the prior rules that we discussed completely done. But we're not in an ideal world, so I guess I will go back and I'll have any of you want to raise questions or provide additional comments on the other rules that we have already discussed. So,
Sorry, this is Chris Wright. Back to table A on those headings, the 244, 171, and 192. I do believe, can you put the full headings in there so people can identify what rulings those are from, what columns those are from?
yes, I mean, a valid point in that we have all of chapter 244 and only part of 171 and 192. So we will try to clarify that one.
Thank you very much.
So just sort of fair notice, I guess. We're looking at the changes, and thank you for the work you've done. And I think these have come a long way. I still have to take them back to my stakeholders within our organization, and I will give as much notice ahead of time as I'm able to ahead of the hearing. But we do reserve the right to bring up issues at that hearing when these go before the full commission. Did I stun you, or did the audio? Okay.
Just taking my notes.
Okay.
No, I frankly, I would expect, I mean, you have to take the final version of the rules back to your stakeholders and your entities and get their input. That's fine.
Yeah, I know you get that. That was mostly for the YouTube audience.
Rob.
And I'll just say ditto to that for the county councils. I'll be meeting with them late this week, but I'll be sharing the final versions with them, and we'll of course give you as much notice if we have ongoing concerns about specific issues. But again, this is mostly for the YouTube audience as well.
Yeah.
I'm sorry, did you call me?
Yeah.
Okay. Susan, I have a question that goes kind of way back to the beginning. After going all through this, I find myself with a question related to public bodies and governing bodies and the definitions. From back the previous meetings, you've made it clear that advisory groups that are advising a individual, official, or not governing bodies, if the official has the ability to take action on the recommendations. My first question is, that advisory group is, however, a public body. Is that correct?
Looking at the definition in 192.610 sub 6. I have to admit, this is my least favorite definition. Public body means any board, department, any state, regional council, county, city, or district, municipal, or public corporation, or any board, department, commission, council, bureau, subcommittee, advisory group, or other agency thereof. So an advisory group of a state, regional council, county, city, district, or any municipal or public corporation would be a public body under that.
So an advisory group advising a single official is not a public body, then, you're saying?
Well, it would depend on how it was formed. Because there are, and this rule, the change I am making to this rule better conform to statute is that an advisory body appointed by an individual public official to make recommendations to that individual public official who has the authority to act on those recommendations would not be a governing body.
I accept that.
Yeah.
Is it, however, a public body as defined by the law? It's
I think
an advisory group.
Yes, I think so under 192.610. I will probably double check that with DOJ counsel, but I think the answer is yes.
And as a public body, would we expect that it would be transparently discoverable and reportable and made known? I mean, that's and then it gets to where I really started to confuse myself was if you had an advisory group like that and 5 people and 3 of those people were asked to go study something and bring a recommendation back to that advisory group, is it possible that those 2 or 3 people would become a governing body because they are going to make a recommendation to a public body, even though that public body is not itself a governing body?
It's a bit of a mind puzzle there, Jeb. And I know you had emailed me about sort of a related question here. I will do my. I mean, I think the answer to the sort of discoverability and the ability of the public to even identify what public bodies, what advisory groups, who is on what, all of that is going to be outside of our jurisdiction and outside of the public meetings law, other than when there is a meeting, the governing body has to identify who is at the meeting. I
understand, and that's I did send you that request because we're about to start gathering a compilation of all of the governing bodies, and as we got to looking at this more closely, we realized that we ought to also be compiling a list of all the public bodies, some of which are not governing bodies. So that was the underlying part of that question, and that's helpful that you would.
The definition of public body in 610 sub 6 is, in my mind, problematic. I understand the reason for it, but I think it gets to this sort of conundrum that you're identifying here, Jeb, where the public body, the advisory group formed to advise an individual public official. So, I form an advisory group to provide advice to me. And I have the authority to take the advice, change the advice, use the advice. And I'm going to then do something with that advice. And you're saying if the group if a subset in the group advises the group, does that turn the advisory body is part of a public body? And is it a separate public body? I have to sort of,
Or for that matter, a separate
I have to
governing
talk-
body. And I don't want to take all your time up here. This is it's kind of a mind game.
it is very much a mind game,
Yeah.
and I will probably talk it through with my DOJ counsel and try to get you an answer.
Yeah, I'd love to get into that conversation with you. So thank you.
All right. I'd also love to get 610 sub 6 rewritten, fixed. Yeah. All right. Any other questions on before we jump all the way back on the matrix or any of that? Okay. So what I guess we could do is I could talk about, and like I said, I wish I had a red line to share with you. I don't at this point. I have made a number of changes though, and I can sort of talk through some of those, or simply have this be an opportunity for you to raise any issues or concerns that have not previously been addressed or raised with respect to the prior rules. Yeah, Nancy.
Will you be allowing us to see the red line version before you forward it on to the committee or the board?
Yes,
Thank you.
this week. Like some of the changes that I'm making based on last week's, things like we talked about body language, nonverbal communication. While I don't think in the rule I can address everywhere where someone could communicate via their body language or facial expressions. I have added sort of nonverbal means to communications to include things like sign language and things like that. I also recognize we had the conversation last time talking about on the grievance process and how grievances could be submitted, added in person, added by fax, added sort of a codicil about how if we're going to have in person, we can set limits on sort of doing it during regular business hours, no showing up at the city recorder's house in the middle of the night, or following them down the grocery store aisle saying, please take my grievance. So anyone as I said, while I quickly look over my red line, does anyone have anything they want to raise? Or reiterate, this is something you think I need to do? Yeah.
I unfortunately missed the last meeting due to a conflict, and I didn't find out whether or not the issue of executive session attendance via electronic means was discussed during the last meeting, or whether there was anything new with that.
It's extensively discussed. Lots of people believe that we don't have statutory authority for the rule. DOJ counsel believes we do have statutory authority for the rule. And the rule accords with advice that we have previously given, which is that the, 192660 sub 4 says representatives of the news media shall be allowed to attend, other than the specific ones that are excluded. We have the authority to adopt and adopt rules necessary to carry out our duties, including the authority to both interpret the public meetings law and to adopt a rule to clarify 192660 sub 4.
Thank you.
We will bring this up in the hearing. It is simply a misreading of the statute to believe that a local government, particularly a home rule entity, is preempted from defining the news media. There is no clear preemption. The DOJ analysis does not look at the Phoenix case, which is the lead case on home rule. That makes it fundamentally flawed. Moreover, we can't confirm via Zoom who is actually on the other end of that call. So given those issues, that can't stay in. We will seek legislation. It's been drafted to clarify this matter. I don't know that we would litigate, but that's something that we would have to make an assessment on, particularly given the nature of some of the issues that we're now allowed to have executive sessions on related to personal security and security of the facility of the city and the safety of our members. We have a strenuous objection to this and do not believe that you have sufficient statutory authority in this matter. You just don't. We have a home rule authority. You cannot foreclose. That is a constitutional protection in this state. You cannot foreclose on that with mere legislative intent or through agency rulemaking process. You need a clear, unambiguous preemption on our authority to make that regulation, and that simply does not exist. Thus ends my speech. I think Rob has another one.
I'm sure he does. But Rob, you'll have to wait your turn. Nancy.
Just a quick question. Speaking of executive session, LOC has done a phenomenal job training all of our elected officials, clearly explaining that anything that they do during the public meeting, whether they're doodling, drawing, coloring, whatever, that is all considered part of the public record. Does the same apply for executive session? If they're texting and they're responding to messages, are those part of the public record?
I can't answer that because we have no jurisdiction over public records law. I mean, my gut and prior experience as an attorney would say yes, but you would need to speak with a public records attorney to get the answer.
Thank you. We were just wondering because it was part of executive session. I was like, you know what? I don't know. Let me ask him. We'll see what we get. Thank you.
Okay, Rob.
As anticipated, I just want to be associated with Scott's comments on behalf of the county council's group, and also note again, just for the record, I believe the legislative history is just to the opposite of what you just said, as I explained in a couple of emails to you. The legislative leadership of the work group that created the two bills that we're talking about implementing here considered that proposal from the media and rejected it. So I agree with Scott's interpretation of the statute. I actually don't even think you have to get the home rule before I think your proposed rule is defective. I think it's defective based on the statute alone, but I understand I'm just saying this for the record.
Okay.
And if I could jump back in, I would point out that if we go back to the penalty matrix and look at advice of counsel, our counsels are going to interpret it. DOJ is not our attorney. So our counsels are going to look at it using what we view as the proper rubric, and that's the advice those counsels are going to get. So you create this because of you now have this conflict between what you're allowed to sanction because of the error in the way this has been interpreted. Because the county council, our attorney is going to look at this and they're going to look at it under Phoenix. And they're going to say, yes, you can, if you adopt the ordinance, the model one that we agreed to with Oregon Newspaper Publishers Association back in 2009, you are not preempted from doing so. They're going to use that rubric. That's going to be the advice they're going to give. They will likely give the city councils. Then you have this council, the OGEC, has significant limitations on how they can sanction that. So it's really quite essential that we get this resolved. I do think the legislature will step in. Unfortunately, we don't think it's actually necessary, shouldn't be necessary for that step to take place, but that's where we're at.
Deb, your hand's up. Did you intend to, can you hear
Oh,
us?
Yes, maybe Scott or Rob might respond to this. First of all, there's, at least with ONPA, there's no clear mandate one way or the other on this, thinking about this executive session attendance by electronic means. There's a great deal of concern about who might be there lingering behind this media person in an executive session that the body wouldn't know about. Given that concern, how is it that it's okay for the members of the governing body itself to be in electronic means to the executive session with the same security issues?
The members of the public body are actually charged statutorily with, or as part of that within the charter, there's an accountability mechanism built into I would be surprised if there's a city in Oregon where we don't have an accountability mechanism built into a executive session attendance and the requirement that those be kept confidential. We have no enforcement right now over a media entity that actually leaks executive session information. We had an incident out, I believe it was in the Dalles, where Therese Bottomley sent a letter to the city asking them to adopt the 2009 ordinance that we had agreed to, or model agreement ordinance that we had agreed to, because of that issue. The city can't even bar, because a blogger attended, broadcast the contents of the executive session, and the city couldn't even bar that person from attending a future meeting. So if a city councilor had done that, there would have been there's usually a removal clause or some other disciplinary function within that charter. For an employee to have done that, that would have probably, I mean, that would be a human resources disciplinary event. So what's our recourse if, and so we have a situation like occurred in Lincoln City where a blogger credentials two of buddies for an individual who's got a HR issue that needs to go in front of the council to attend the executive session. If that blogger had just say attended via Zoom, what would have been our recourse? And let either the recipient or the person involved or the person's friends attend that meeting virtually, we would have had no recourse. The city councilor could have done that. They probably would have been removed.
I could just add, I agree with everything that Scott just said, but to put a more positive reflection on it, Jeb, I think if the media and the legislature were able to codify a definition of media so we could avoid that last example that Scott gave, and that is a distinction. We can identify who the city councilors are, who the commissioners are, but right now under statute, we can't identify who is the media. It could be essentially the person we're holding the executive session about or someone related to them. So if we could define that in statute, that would be one thing. We've tried and not been successful in that endeavor. And so that's why it defaults to home rule, at present. But the other thing is accountability. We don't have any remedy against the media if the media blows an executive session. This is precisely how the media lost its right to be in two types of executive sessions. This is long predates you and I, but the media blew a few executive sessions in those two other categories, and the legislature's only remedy they could come up with was to take the media's right to be there away. And in this case, there would be no remedy. So, maybe we could talk about that, but it sounds like OGEC's going to put it in rule. I don't know where that's going to lead to, probably legislation or litigation. I probably won't be involved in either, but that's where I'm guessing this is going.
Thank you.
Let's take a 10-minute break. I will see if there are any additional edits that we need to cover, and then we can talk about the next step, which is creating a separate rack for next Monday's meeting. Yes. Okay, welcome back, everyone. Any questions or comments for anyone have on the rules so far? I will circulate the final, I will take your comments today, see if I need to make any additional red lines, and I will circulate the final red line version by Wednesday at the latest. So that brings us to the next steps. In order to have the RAC provide review and provide recommendations on the fiscal impact statement, plan was to present it to you today, however, but in order to do that, you actually do have to be appointed by the commission for that purpose. And so we have scheduled a commission meeting for tomorrow afternoon for the commission to appoint a rules advisory committee to review and make recommendations on the fiscal impact statement. Yeah, in my ideal world, all of you will agree to be a member of that RAC. And we would have the commission appoint you to that separate RAC at their meeting tomorrow. So what I'm going to do is, for those of you here, it may be limited to those of you unlucky enough to show up here today, is have Casey go through the roll call and have you indicate whether you are agreeing to serve on that RAC. That RAC will be meeting next Monday. At Monday's RAC meeting, we will go through the final version of the rules. We will go through the fiscal impact statement, the need for the rules, the notice, the racial equity statement, the whole thing is all part of one. And get the committee's, the RAC committee's recommendations on the fiscal impact statement and any additional comments or reactions to the completely revised rules. So what I am asking now is, are you willing to serve on this commission appointed RAC that will be meeting next Monday afternoon? So I will have Casey read the roll call and please indicate your willingness.
Okay, Adam Abplanalp. Beth Woodard.
Yeah, for sure. I'll agree. Thank you.
Thank you. Brenda Sanchez. You're on mute, Brenda, if you were trying to respond. And if you can't respond and you just want to put it in the chat, that will work too, whatever your response is. Carolyn Shields. Courtney Sneed. Chris O'Grady.
Yes.
Thank you. Rogav Shan. Gabe Shepard.
Yes.
Thank you. Hasina Wittenberg. Jeb Ladine.
Yes.
Thank you. Joe Barker. Corey Tate.
Yes.
Thank you. Chris Wright.
Yes.
Thank you. Liz Fouther Branch. Mallory Roberts. Matthew Call.
Yes.
Thank you. Michelle Smith. Nancy Sandoval.
She did a thumbs
Yes.
up.
Thumbs up from Nancy. Thank you, Nancy. Rob Bovet.
Yes.
Thank you. Sarah Zavala.
Yes.
Thank you. Scott Winkles.
Yes.
Thank you. Sherry Kinsey. Therese Holmstrom. And Tiffany Johnson. All right, thank you.
Okay, I appreciate it.
I'm sorry, this is Brenda Sanchez. I might have missed your check-in.
Oh, yeah, I'm sorry, Brenda. Are you willing to participate on the fiscal impact RACT that will meet next Monday?
Sure, I'll do it.
Okay, great. Thank you.
Okay, any final thoughts or comments? If not, I will let you all go early and
Did we want to email the ones that were not in attendance
yes,
today?
I will.
Okay.
I will email any who were not here and extend the invitation to them as well and get a response.
I just wanted to get on the record that that
Yeah.
was going to be happening, just so.
Okay, well, then we will leave early today and I will send all of you the red line and as well as the draft of the fiscal impact statement.
Matthew has.
Oh, Matthew.
Oh, sorry, hit it by accident.
Oh, okay, sorry. I will send all this stuff out to you on Wednesday and otherwise, and we will send a confirmation after our commission approves, presumably approves the racket. It's meeting tomorrow afternoon. And otherwise, we will meet at least for one more time next Monday afternoon. All right, thank you, everyone.
Thank you.
Thank you.
Thank
Have
you.
a great week. See you tomorrow. Bye.
Did you want me to schedule a meeting